The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, and thank you for joining us for NCEA's webinar, The Every Student Succeeds Act, Impact on Private Schools, brought to you in partnership by the U.S. Department of Education. I am Andrea Cobb, Manager of Educational Resources for NCEA, and I'm happy to host this webinar for you today. Before we begin, please know that all of your microphone connections have been muted. If you have questions during today's presentation, please send those through the question box that appears in your GoToWebinar panel. To ask a question, use your mouse to click into the blank box area. Type your question using your keyboard and then click Send. The webinar presentation will last about an hour. You can post questions at any time throughout the presentation, but our presenters have a lot of content. If they don't get to your questions during the presentation, they're going to be sharing their contact information with you so you can ask them directly afterwards. Immediately following the webinar, you'll be prompted to complete a brief survey about your webinar experience. I thank you in advance for providing us with this valuable feedback. For those of you who are attending the webinar live, you'll find a copy of the presentation materials and a certificate of attendance in the Handouts section of your GoToWebinar panel. You'll receive an email tomorrow with instructions on accessing this recording. Let us begin, as we do all things, in prayer. In the name of the Father, and of the Son, and of the Holy Spirit, amen. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done, on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. Amen. In the name of the Father, and the Son, and the Holy Spirit. Amen. Now I'm happy to introduce our presenters. Maureen Dowling, Director of the Office of Non-Public Education for the U.S. Department of Education, along with Management and Program Analysts Isadora Binder and Janae Morrissey. Thank you, ladies, for joining us today.
Thank you, Andrea. My name is Maureen Dowling, and I'm the Director of the Office of Non-Public Education at the U.S. Department of Education. And we are so pleased to partner with the National Catholic Educational Association on today's webinar on the Every Student Succeeds Act and the equitable participation of private school students and teachers. So what are the objectives for the participants in today's webinar? We hope you will gain a better understanding of the new provisions under the Elementary and Secondary Education Act, or ESEA, as amended by the Every Student Succeeds Act, or ESSA or ESSA, as I'll be referring to it, particularly as they apply to equitable services, and gain awareness of resources to assist you in understanding current and new provisions that need to be implemented, monitored, and enforced. So our agenda for the webinar includes a little bit of background information on the Office of Non-Public Education, and then we'll also provide just some very background information about the new guidance that the department released on the equitable services provisions under ESSA, and then I'll be turning it over to Isadora and to Janae, and they're going to delve into that guidance, talk to you about the new and changed provisions that are in both Title I, Part A, and Title VIII, and then specific provisions that have changed in Title I and new ones in Title VIII. And then we hope to have some time to answer questions from the participants. However, if you don't have an opportunity to send us a question, or if your question isn't answered, we hope you'll send it to us at onpe@ed.gov. The next slide just shows the names of the presenters and that we work for the Office of Non-Public Education. Okay, just a little bit of background. Since 1965 and the passage of the Elementary and Secondary Education Act, the law has required local education agencies, or LEAs, to provide equitable services to private school students, teachers, and in some cases parents in a number of the ESEA programs. Perhaps you've heard of some of them, such as Title I, or Title II, Title III, Title IV. We'll talk a little bit more about them moving forward. Now, this was based on the child benefit principle, meaning that a child who met the eligibility requirements could receive services regardless of the school the child attended. In a sense, Congress was school blind as they passed that first Elementary and Secondary Education Act. It's also important to note that, like their public school counterparts, private school students, including low-income private school students, generate some of the federal education program funds that are allocated to states and local educational agencies. At the same time, though, and of most importance, be aware that equitable services are not provided in the form of money to private schools. Rather, equitable services are provided through the LEA in the form of direct services to eligible students, teachers, and in some cases, parents. This next slide gives you a little bit of information about the law. So it was signed, the Every Student Succeeds Act, ESSA, was signed into law on December 10th, 2015. However, currently, through this current school year, the No Child Left Behind Act remains in effect. ESSA goes into effect in the 2017-2018 school year. In general, you should know that ESSA strengthens and really enhances the equitable services provisions and actually provides for more state and district level accountability. If you look at the chart here, to help you understand this, on the left-hand side we have the No Child Left Behind Act. Again, it remains in effect through this school year. And the equitable services provisions are found in Section 1120 in Title I and in Title IX under the No Child Left Behind Act. Under ESSA, which will go into effect beginning with the 2017-2018 school year, the equitable services provisions in Title I are now found in Section 1117. And the equitable services provisions formerly found in Title IX will now be found in Title VIII. Now, important to note, Title I Part A has its own governing provisions, thus Section 1117. Title VIII governs a number of other programs, such as Title I Part C, the education of migratory children, Title II Part A, supporting effective instruction, Title III Part A, English language acquisition, language enhancement, and academic achievement, Title IV Part A, student support and academic enrichment grants, and Title IV Part B, 21st Century Community Learning Centers. So to find out how equitable services works for these programs that I just mentioned, you go to Title VIII. Okay, we are so pleased that in November the department released new non-regulatory guidance specific to the equitable services requirements. That guidance document is called Fiscal Changes in Equitable Services Requirements, Non-Regulatory Guidance. This guidance is going to be a helpful tool at the state and local level and for private school officials. Now, it primarily focuses on requirements that are new or changed from NCLB. Because most of the equitable services requirements of NCLB were carried over into ESSA, moving forward into the 2017-2018 school year, LEAs and private school officials will use the new non-regulatory guidance, but also will need to refer to the Title I Services to Eligible Private School Children non-regulatory guidance and the Title IX Part E Uniform Provisions Private Schools non-regulatory guidance. So you might be asking, why would we be using old guidance? Again, not everything in the old guidance transfers over, and you'll know that as we go through this new non-regulatory guidance, but a lot of what's in the Title I Equitable Services Guidance and the Title IX Equitable Services Guidance does carry over. All right, before I hand the presentation over to Isadora, I just want to tell you real quickly about the Office of Non-Public Education. Perhaps many of you participating on this call know about us. We are the liaison office to the non-public school community, including private, faith-based, and home schools. We're here at the department to provide guidance and support to you and states and local educational agencies as you seek to gain knowledge on federal education programs and the participation of private school students and teachers. Our statutory mission is to facilitate maximum participation of private school students and teachers in federal education programs and initiatives. We do that through a number of ways, such as this webinar we're conducting today with NCEA. Within the department, we offer advice and guidance on all matters affecting non-public school students and teachers. We communicate with national, state, and local non-public school associations on these matters and have had a long-standing and good positive relationship with NCEA. Within the department, we work with practically every other program office in order to ensure maximum participation of private school students and teachers in federal education programs. This slide shows our home web page, and I know it looks real busy, but we encourage you to take an opportunity to investigate it. We have a page specifically for the Every Student Succeeds Act, and we are updating that page regularly. It's where you can also find out about webinars and recordings of webinars, in addition to guidance and regulatory and statutory resources. Finally, I hope that you'll consider signing up for the ONPE listserv. By doing so, you will be getting the most current and up-to-date information on federal education programs and the participation of private school students and teachers. So again, thank you for joining us today. Thank you to NCEA for hosting this webinar, and I'm going to turn it over to my colleague, Isadora Binder.
Thanks, Maureen. Okay, so this section of the presentation will review those changes that are common to the equitable services requirements under both Titles 1 and 8. ESSA includes a new statutory requirement regarding the designation of an ombudsman. To help ensure that private school children, teachers, and other educational personnel receive services equitable to those in public schools, state educational agencies must designate an ombudsman to monitor and enforce Title I and Title VIII equitable services. I would just like to make a note here that we've included at the bottom of each slide the statutory reference for the particular provision along with the FAQ and the non-regulatory ESSA equitable services guidance. What are the roles and responsibilities of an ombudsman? An ombudsman should serve as an SEA's primary point of contact for addressing questions and concerns from private school officials and LEAs regarding the provision of equitable services under Titles 1 and 8. In addition, the Ombudsman is required to monitor and enforce the equitable services requirements under Titles 1 and 8, and thus should have a significant role in the state's monitoring process. Furthermore, the Ombudsman should ensure that private school officials know how to contact the Ombudsman. The following are examples of activities the Ombudsman could undertake in fulfilling the roles and responsibilities of the position. Serve as a general resource regarding equitable services requirements for both LEAs and private school officials, which may include conducting initial outreach to define the contours of the Ombudsman's responsibilities. Develop in partnership with other relevant staff monitoring protocols applicable to the provision of equitable services and participate in a sample of any monitoring activity. Provide technical assistance regarding equitable services requirements for SEA staff administering applicable programs, LEA staff, and private school officials. Establish a process for receiving documentation of agreement from LEAs consistent with the consultation requirement that the results of such agreement shall be transmitted to the Ombudsman, and participate in the state's Title I Committee of Practitioners and as applicable non-public school working groups. What about the Ombudsman's monitoring and enforcement responsibilities? The primary responsibilities of an ombudsman are to monitor and enforce the equitable services requirements in Titles 1 and 8. An ombudsman should work with SEA staff administering Title I and programs covered under Title 8 to develop monitoring protocols and protocols applicable to the provision of equitable services under each program. To ensure that monitoring protocols are being followed, the ombudsman should take an active role in the monitoring process, particularly with respect to the resolution of any findings regarding equitable services requirements under Titles 1 and 8. The Ombudsman also should serve as the primary point of contact for responding to and resolving any complaints regarding equitable services that the SEA receives under its SEA complaint procedures. What are the qualifications of an Ombudsman? An SEA has discretion in determining who to designate as an Ombudsman. In determining the relevant qualifications of the Ombudsman's position, an SEA should consult with appropriate private school officials. Within most states, there is a statewide private school coalition with representatives of the various private schools within the state. SEAs might consider engaging such private school coalitions. An SEA should consider the following factors in determining who will serve as an ombudsman. Knowledge. Does the individual have sufficient experience and demonstrate thorough knowledge and understanding regarding the equitable services provisions, including the statute, regulations, and guidance necessary to implement, monitor, and enforce the equitable services requirements under both Titles 1 and 8? Capacity. Will the ombudsman work alone or in collaboration with other state federal program directors? Does the individual have experience integrating input from other technical experts and program specialists, including those at the U.S. Department of Education, and communicating it to the appropriate audiences? And impartiality. Will the individual be able to carry out the ombudsman duties, including monitoring, enforcing, and resolving complaints in a fair and impartial manner? Will the individual be able to provide guidance to the LEAs and private school officials to facilitate the goal of reaching agreement when agreement cannot be achieved independently through consultation? What about the funds to support the ombudsman? If an SEA consolidates state administrative funds under ESEA Section 8201, it may support its ombudsman using those funds. If an SEA does not consolidate state administrative funds, it nonetheless may support its ombudsman using funds reserved for state administration under Title I and the covered programs under ESEA Section 8501B. Under these circumstances, however, the SEA must ensure that the ombudsman's salary is charged to each program based on the relative benefit received. When does the ombudsman need to be designated? Under the Consolidated Appropriation Act of 2016, the equitable services requirements under the ESEA as amended by NCLB continue to apply through the 2016-2017 school year. However, an LEA must consult with private school officials to plan for the 2017-18 school year before it makes any decision that affects the opportunity of eligible private school children, their teachers, and their families to participate in Title I or covered programs under Title 8. Thus, an SEA should designate an ombudsman in sufficient time to be of assistance as LEAs and private school officials begin the consultation process for the 2017-18 school year, which would generally occur in the late winter, early spring 2017. If you have identified a state ombudsman, we welcome you to submit their contact information to onpe@ed.gov. This is helpful as ONPE seeks to establish new relationships with designated ombudsmen.
Isadora, this is Maureen. Just a note on that. If you don't know who your ombudsman is, you could certainly contact your state educational agency and ask them who that ombudsperson is.
Thanks, Maureen. ESSA includes a new statutory requirement regarding the obligation of funds. Funds allocated to an LEA for educational services and other benefits to eligible private school children, teachers, and other educational personnel and families must be obligated in the fiscal year for which the funds are received by the LEA. The purpose of this requirement is to ensure that an LEA uses the funds available under Title I or a covered program under Title VIII to provide equitable services in the fiscal year for which the funds were appropriated to ensure that eligible students, teachers, and other educational personnel and families receive the services to which they are entitled in a timely manner. This provision reinforces the requirement that an LEA conduct timely consultation with private school officials to designate appropriate equitable services so that those services can begin at the beginning of the school year for which the funds are appropriated. And I would just like to make a note, if you wouldn't mind, Andrea, going to the last slide with regard to identifying the Ombudsman. Just as Maureen pointed out, if you don't know who your Ombudsman is, contacting the state or the LEA is essential because you are not responsible for identifying or finding or appointing the Ombudsman. That is the role of the state. Okay, so on to slide 18. Some of you might be asking whether carryover is permissible. In general, to ensure that equitable services are provided in a timely manner, an LEA must obligate the funds allocated for equitable services under all applicable programs in the year for which they are appropriated. There may be extenuating circumstances, however, in which an LEA is unable to obligate all funds within this time frame in a responsible manner. Under these circumstances, the funds may remain available for the provision of equitable services under the respective programs during the subsequent school year. In determining how such carryover funds will be used, the LEA must consult with appropriate private school officials. It is important to note that carryover from funds allocated for equitable services must be expended for equitable services. It's also worth noting that obligating and expending funds are different. The law requires that Title I funds for equitable services be obligated in the year for which they were appropriated. However, this does not preclude the LEA from expending such funds in the summer or the following year in consultation with private school officials. ESSA includes a new statutory requirement regarding allocation. An SEA must provide notice in a timely manner to appropriate private school officials in the state of the allocation of funds for educational services and other benefits under each ESEA program that the LEA has determined are available for eligible private school children, teachers, and other educational personnel and families. What are the requirements to provide notice to private school officials? An SEA must annually provide information on the amount of funds by program allocated for equitable services that each LEA responsible for providing equitable services has determined are available for eligible private school students, teachers, and other educational personnel and families. This applies to Title I, including the amount for parental involvement and each covered program under ESEA Section 8501B. Such documentation should indicate how the allocation was determined. An SEA should consult with appropriate private school officials to determine an effective manner for disseminating the notice of allocation to appropriate private school officials, which may include notification through the Ombudsman. An SEA may consider methods such as publicly posting this information on the SEA's website, using an email distribution list of private school officials, or other method that will ensure that this information is available to appropriate private school officials. An SEA should consult with LEAs and appropriate private school officials to determine a reasonable timeline for providing the notice of allocation. In general, an SEA should ensure that the notice is provided prior to the beginning of the school year. ESSA includes a new statutory requirement regarding when the state must provide equitable services. An SEA must provide equitable services directly or through contracts with public or private agencies, organizations, or institutions. If appropriate, private school officials have requested that the SEA provide such services directly and demonstrated that an LEA has not met applicable equitable services requirements in accordance with the procedures for making such a request as prescribed by the SEA. I'd like to review some guidelines regarding the procedures for governing a request for the state to provide equitable services. An SEA should consult with appropriate private school officials in developing procedures under which private school officials may request the SEA to provide equitable services in lieu of an LEA. It is likely that most instances of non-compliance with equitable services requirements by an LEA can be corrected with minimal intervention by the SEA. Consistent with the standards the Secretary must use for a bypass, under the equitable services requirements in Titles 1 and 8, an SEA must develop procedures that require private school officials to demonstrate that an LEA has substantially failed or is unwilling to provide equitable services before the SEA intervenes to provide equitable services directly or through a third-party provider. Please note that a bypass is a means by which the Secretary directly provides equitable services to private school students and teachers through a third-party provider. An SEA should make available a standard template for requests and have transparent procedures for evaluating such requests. ESSA includes a new statutory requirement regarding consultation that applies to Titles 1 and 8. The goal of consultation is agreement between the LEA and appropriate private school officials on how to provide equitable and effective programs for eligible private school children. A note on school choice. Participation in a federal or state private school choice program does not affect a private school student's eligibility for equitable services under an ESEA program. Regardless of the source of funds paying a private school student's tuition, a student is eligible for equitable services under the ESEA if the student meets the eligibility requirements of the respective program. So this next section of the presentation will review those changes to the equitable services requirements under Title I.
Isadora, this is Maureen again. Just before you move forward, I would just love to reiterate that all those provisions that you just went over are applicable to all the programs that require equitable participation. So Title I Part A, and then all those programs that are governed by Title 8. Okay, take it away.
Sure. All right. So these are the provisions that are covered under Title I exclusively. So, consistent with Title I equitable services requirements under NCLB, LEAs must determine the funds available for equitable services on a proportionate basis. ESSA, however, made some changes that affect the methodology of LEAs, LEAs use for calculating the proportionate share. Significantly, as you can see in the last sentence of this slide, the statute now requires an LEA to determine the proportionate share based on the total amount of Title I funds received by an LEA prior to any allowable expenditures or transfer of funds. What this means is that in allocating funds for equitable service, an LEA must determine the proportionate share based on the total amount of Title I funds it receives prior to any reservation taken off the top, including reservations for administration, parental involvement, and district-wide initiatives. This is a fairly significant change because under NCLB, equitable services funding was determined after reservations. This resulted in a fairly complex method for calculating funding as, although equitable services did apply to certain reservations, it did not apply to others, such as funds reserved for supplemental educational services. Because equitable services funding now must be determined prior to any reservations, we think the process will be much less complicated. To determine the proportionate share, an LEA would first determine the number of children from low-income families residing in each participating public school attendance area who attend public schools and private schools. Given that it will be difficult for an LEA to determine the participating public school attendance areas until it knows the amount of funding available, for purposes of determining the proportion amounts, we think that the best way to do this would be to use the data from the preceding school year. For example, in determining the proportionate share of services in the 2017-18 school year, an LEA would use low-income data from the 2016-17 school year. This could be either fall data or spring data as long as it is obtained at equivalent points in the school year for both public and private school students. The LEA would then determine the overall proportion of children from low-income families who reside in participating public school attendance areas and that attend public school and private schools in each attendance area. Using the proportion of children from low-income families who attend private schools, the LEA would determine the amount of funds available for equitable services based on that proportionate share of the LEA's total Title I allocation. Once the LEA determines the proportionate share for both public and private schools and reserves funds as appropriate, it would then determine the public schools to be served through the normal rank and serve process. This would establish the participating public school attendance areas that would then serve as the basis for determining funds for providing Title I equitable services in specific private schools, most likely using the same per pupil amount for each private school student. Okay, so the following example contained in the new guidance reflects how the LEA calculates the proportionate share for equitable services. In this example, an LEA with 4 Title I public school attendance areas, a total of 1,500 low-income students, and a total Title I allocation of $1 million would determine the total amount available for all equitable services activities, the proportionate share, as follows. Now I'd like to use my mouse, and unfortunately I know that my mouse will not show up as I move it around on the screen. So bear with me as I walk you through this example. So let's start with column 3, the number of private school low-income children. The total number of private school low-income children is 150, which is 10% of the total 1,500 public and private school low-income students. Thus, the LEA would multiply the total $1 million Title I allocation by 10% to determine the proportionate share for Title I service for eligible private school children. In this example, the total proportionate share for Title I services for private school children is $100,000. Thank you, Andrea. Next, let's look at column 2. The number of public school low-income children. The number of public school low-income children is 1,350, which is 90% of the total 1,500 low-income students. Thus, the LEA would multiply the total $1 million of the Title I allocation by 90% to determine the proportionate share for Title I services for eligible public school children. In this example, the total proportionate share for Title I services for public school children is $900,000. Note that at this stage, you could calculate a per pupil amount by dividing the proportionate share by the number of low-income students in both public and private schools, meaning dividing $1 million by 1,500. This amount would be the same for all students, which is approximately $667 per child. In practice, however, the actual per pupil amounts will differ once the LEA calculates reservations for parental engagement and administration for both the public and private school components of the program, which we will touch on next, and considers any other reservations that the LEA decides to take off the top of its public school proportionate share. For example, for district-wide initiatives, and the ranking and serving of public schools. We're going to move to the next slide. Thank you. I'd like to turn now to address a couple of specific reservations, beginning with the LEA reservation for administering the Title I program. Previously, LEAs reserved funds for administration off the top prior to determining the proportionate share for equitable services. These funds were then used to administer the Title I program as a whole, including both the private and the public school components of the Title I program. As before, an LEA may reserve an amount that is reasonable and necessary to administer equitable services. Under ESSA, however, an LEA will need to use a different methodology given that the proportionate share must be calculated before any reservations. Specifically, from the proportionate share of Title I funds available to provide equitable services, an LEA determines the amount needed to administer the private school component of the program separately from the amount needed to administer the Title I component of the program for students in public schools. The LEA should discuss the administrative costs for implementing equitable services during the consultation with appropriate private school officials. The other reservation that remains relevant to equitable services is the reservation for parental and family engagement. An LEA must reserve and spend at least 1% of its total Title I allocation for parent and family engagement activities if the LEA's Title I allocation exceeds $500,000. To determine this amount, an LEA must calculate 1% of its total Title I allocation. Of course, this is slightly complicated given that the proportionate share is also based on the total allocation. So this is how it would work. The LEA would again look at its total allocation and determine what 1% of that amount is. The LEA would then apply the proportionate share percentage for services to private school students to determine how much it must spend for parent and family engagement activities for the families and parents of eligible private school and public school students. An LEA must then spend that amount from the proportion of its Title I allocation available for equitable services for private school students. The following example contained in the new guidance reflects how the LEA calculates equitable services for parents and families of eligible private school children. Using the same Title I funding amount as in the previous example, the LEA has a Title I allocation of $1 million, as noted in the first column on this table. Let's move over to the second column. The LEA must reserve 1% of its total $1 million Title I allocation for parent and family engagement. Thus, 1% of the LEA's total $1 million Title I allocation is $10,000. So $10,000 must be expended for parent and family engagement. Okay, so from this total amount of $10,000, how does the LEA determine the amount that must be expended for equitable services for private school parents and families? Recall from the previous example, the LEA allocated 10% of its $1 million Title I allocation, which is $100,000, for Title I equitable services for private school students, and 90%, which is $900,000, for all Title I activities for public school students. The LEA would use the same proportions, 10% and 90% in determining the amount of funds allocated for parent and family engagement. So now look at column 3, proportionate share for equitable services for private school parents and families. The LEA must use $1,000, which is 10% of the total $10,000 that must be expended for parent and family engagement for private school students, parents, and families. This $1,000 is taken from the amount allocated for Title I services for private school students. So as you can see in the last column, from the total $100,000 allocated for Title I services for private school students, $1,000 of that amount must be expended for parent and family engagement. The remaining $99,000 will be used for instruction and professional development for private school students and teachers. In turn, the LEA must spend 90% of the total $10,000, which is $9,000, on Title I activities for parent and family engagement in the participating public schools. This amount is taken from the public school Title I proportionate share, which you may recall is $900,000. In summary, a total of $10,000 must be expended for parent and family engagement. 10% of that $10,000, well, $1,000 must be expended for private school parents and families. 90%, or $9,000, must be expended for public school parents and families. The $1,000 is taken from the proportionate share for private school students, and the $9,000 is taken from the proportionate share for public school students. Moving on from funding issues, there are a couple of other new requirements specific to Title I that I'd like to touch on. One of these is the results of agreement following consultation must be transmitted to the SEA's Equitable Services Ombudsman. The Ombudsman should establish a process for receiving documentation of agreement from each LEA. For example, the Ombudsman may direct an LEA to document agreement on the same form the LEA uses to document affirmation of consultation and submit that form to the Ombudsman. Other changes under ESSA affect the statutory list of consultation topics, which have been expanded to include how the proportion of funds allocated for equitable services is determined, whether the LEA will provide services directly or through a separate government agency, consortium, entity, or third-party contractor, whether to provide equitable services to eligible private school children by pooling funds or on a school-by-school basis, when, including the approximate time of day, services will be provided, whether to consolidate and use funds available for Title I equitable services in coordination with eligible funds available for equitable services under programs covered under Section 8501B to provide services to eligible private school children in participating programs. I'll touch on a couple of these more specifically in a moment. Under NCLB, LEAs were required to maintain and provide to the SEA a written affirmation signed by officials from each participating private school that meaningful consultation had occurred. ESSA adds to this requirement by further requiring the written affirmation provide the option for private school officials to indicate their belief that timely and meaningful consultation has not occurred, or that the program design is not equitable with respect to eligible private school children. The option to either pool funds for multiple private schools or provide services on a school-by-school basis is unchanged. The only change is that the new statute now specifies that an LEA must consult with private school officials regarding these options. Please remember that funds cannot be pooled across programs or LEAs. As part of consultation, an LEA must consider whether to consolidate and use Title I funds to provide equitable services under Title I in coordination with funds for equitable services from programs covered under Title VIII. The focus here is really to foster increased coordination among different programs under which an LEA might provide services to students in a particular private school. This can help address the silo effect, whereby the nature of services under Title I is often determined without regard to what services are being provided under other programs with equitable services requirements, such as Title II and Title III. For example, through coordination, an LEA with limited available funds might use Title I funds to provide instructional services to Title I eligible private school students, use Title II funds to provide professional development to those students' teachers, as opposed to all teachers in a given school, use Title III funds to improve the English proficiency of English learners among the participating students, and use Title IV funds to provide necessary counseling services to the most at-risk students, eligible students. In coordinating Title I equitable services with other programs, funds would continue to be used for allowable activities under each program, but the coordinated services would allow the LEA to better serve the needs of the most at-risk students in a comprehensive manner. Coordination between programs will eliminate the silo approach through which an LEA consults with private school officials on a program-by-program basis. So this concludes the section that relates specifically to Title I, and I'm now going to pass it on to Janae, who's going to discuss issues related to Title VIII.
All right, thank you, Isadora. Okay, as Isadora said, I'm going to be discussing the programs that are covered under the Title VIII uniform provisions. And Maureen already covered this in her opening, but I thought I would just review it quickly. As previously discussed, the uniform provisions that were previously found under Title IX Part E are now located in Title VIII Part F. And the first notable change in the uniform provisions are the covered programs. So under NCLB, the uniform provisions applied to 9 different programs, though many were no longer funded. ESSA has cleaned it up a bit, and now the uniform provisions cover 5 programs: Title I Part C, Title II Part A, Title III Part A, and Title IV Parts A and B. Now at this time, there is no new guidance specific to equitable services under the individual programs. So all new and changed requirements are covered in this fiscal guidance package. However, as Maureen mentioned also, the previous non-regulatory guidance for equitable services under Title IX as well as Title III may still be applicable as appropriate in addition to the new guidance. Okay, now while we have not provided any guidance on this topic, I do want to point out a small change in the complaint process, which applies to both Title I and programs covered by Title VIII. The time frame for a response from the state has changed from, quote, a reasonable period of time to a specific period of time of 45 days. Likewise, the period of time by which the Secretary of Education shall investigate and respond to any appeals has been shortened from 120 days to 90 days. Now, similar to changes in consultation requirements under Title I, there are a few added topics for consultation under Title VIII, and they include how the proportionate share of funds is determined, whether services will be provided directly or through a separate government agency, consortium, entity, or third-party contractor, and whether to pool funds for equitable services. One other new topic under consultation is that documentation of consultation is now required. That was required under Title I, but not the programs under Title IX previously. ESSA has now added this for the Title VIII programs. All right, the next slide is actually just a helpful graphic to provide a reminder of the ongoing nature of consultation and all of the topics that should be discussed. So on the left in blue are the existing requirements that carried over from NCLB into ESSA, and on the right in red are the new additions. So the new topics that must be discussed during consultation. I do want to note that the options to pool funds or provide equitable services on a school-by-school basis have not changed, so just like what Isadora discussed under Title I. So while we have previously recommended through guidance that all the options be discussed, the statute now specifies that this must be discussed in consultation. And just to note, the definition and descriptions of pooling that are found in the prior Title IX guidance are still applicable and may be useful for you in consultation. Now I'm going to switch over just a little bit and talk more specifically about Title II, Part A, which is covered by the Title VIII Uniform Provisions. Under NCLB, the amount of funds reserved for equitable services under Title II, Part A was limited to the amount of funds the LEA spent on professional development for its own teachers, or what we also called the hold harmless, which was an amount determined by the amount spent under the Eisenhower PD program and the class size reduction funds used for PD in 2001. And so it was based on whichever was greater, what the LEA was actually spending on professional development or that hold harmless. ESSA removed this provision. Now, all equitable services allocations for programs covered by the Title VIII Uniform Provisions shall be equal, taking into account the number and educational needs of children to be served, to the expenditures for public school children, after administration costs are considered. So the cost of administration of the equitable services, including the administration of services provided through a third-party contractor, should come from the district's off-the-top administrative set-aside. So this is different from how the set-aside for admin is done for Title I, so just take note of that. This slide is just a chart giving you an example of a formula to help determine the amount to be reserved for Title II, Part A equitable services. You can see in the A category we've listed the enrollment numbers for both the public and private schools and come with the total number. Then in the B section we've listed what the LEA total allocation is, what they're reserving for administrative costs, and then what remains of the allocation after admin is taken off. That amount is then divided by the total student population, so total student enrollment. And once you arrive at that number, you can then multiply that PPA by the total number of private school students to come up with the amount available for equitable services. And this chart is available in the guidance. So just as the allocation amount for Title II equitable services was limited to the amount the LEA spent on PD, the use of those funds was limited strictly to professional development activities. Now the allowable uses of funds has changed for Title II Part A, and there may now be some additional uses of funds permissible for equitable services. Still, Title II Part A funds may not be used for class size reduction in private schools. Now the statute does not indicate the activities that may be, but we have provided some guidelines for determining the allowableness of specific activities. They must, first, be an allowable use of funds under statute, which would be ESEA Section 2103B3, and I'll discuss that a bit further in the next slide. Must also meet the specific needs of students enrolled in the private school and not the school itself. Must be provided by either an employee of the public agency or through a contract by the public agency with an individual, association, agency, or organization who must be independent of the private school and any religious organization. All contracts must be under control and supervision of the public agency. Additionally, all funds must remain in control of the public agency responsible for providing equitable services. Now, regarding the changes to the allowable uses of funds under Title II Part A, Section 2103B3, and I'm sorry for that typo on the slide, it should be 2103B3, not E. This states that professional development may be provided as long as it is evidence-based, to the extent the state determines that such evidence is reasonably available. In addition to professional development, Section 2103B covers many other allowable uses of funds, which we do recommend reviewing. Furthermore, last October, the Department released new non-regulatory guidance for Title II Part A that you may find helpful in determining appropriate activities for meeting professional development needs. And you can find it at the link in this slide, or it's also on our resource pages at the end of this presentation. So one final note. The requirement that the SCA provide equitable services with any state-level activity funds has not changed. The SCA must consult with appropriate private school leaders in the state to determine the services that may be provided. And the amount of funds available for equitable services at the state level is based on the amount of funds reserved under Sections 2101C1 and 2101C3 for Title II Part A, and is calculated on a per-pupil basis. Now, our final few slides are just lists of the resources that are available. We have resources specific to ESSA, the new guidance that has been released, as well as the pertinent guidance that was released under NCLB that may continue to be helpful for you. And then finally, we have a slide with our contact information. We encourage you to reach out to us. You can email us anytime at the onpe@ed.gov mailbox or call us directly. Also, check out our webpage. Maureen showed you in the beginning of our presentation. There's lots of resources on our webpage that may be useful for you. So we encourage you to do that. And now, I don't know, with time wrapping up, I will turn it back over to Andrea.
Thank you, Janae. I want to remind our audience before we conclude to visit our website at ncea.org to see listings for both upcoming webinars and professional development events. I want to thank all three of you for spending your time with us today as presenters. Thank you, Maureen, Isadora, and Janae, for all of your wealth of knowledge and experience and all the resources that you've curated for us. To our audience, if you did not get your question answered today during the presentation, please reach out to them directly, and they'll be happy to get back to you. As a reminder, I will be sending you this recorded webinar, the presentation materials, and a certificate of attendance via email tomorrow. Thank you all again, and may you enjoy a blessed evening.